Oh, I just broke this. What did I do?
I didn't know you were videoing on YouTube. You should have told me we could have set it up.
Hey everybody, so I am here live streaming. I'm sorry that I'm a couple of minutes late. We had some technical difficulties and I did break my tripod. So in any case, while I readjust this, I want you to start asking me your questions. I am super excited, like always, to answer your burning questions about trademark topics that affect you, because we all know that you guys have questions because I get calls and emails and Facebook messages, etc. So let me try to readjust this real quick. 1 second. Hold on. Okay. Okay, I think that's a little bit better. So I am on here today because I want to talk to you about some of the most commonly asked questions that I get. And if you are new to business, you're probably asking yourself one of the most basic questions, which is, what in the world is a trademark? And so a trademark protects any word, slogan, tagline, company name, and I want you to know that every company usually has more than one trademark. So I know that one of the other commonly asked questions is, should I just have my one trademark for my company name? And the answer is, listen, it all depends on how you want to protect your brand. So you can protect your brand with just one trademark, you can protect your brand with 2 trademarks, 3 trademarks, 4 trademarks. But this is the catch, okay? The catch is that you have to be using all of those trademarks in the proper way, or intend to use them in the proper way. So this is what usually happens is somebody says, I absolutely love, I don't know, the name XYZ. And they're like, I really want to trademark XYZ because I love it and I don't want anybody else to take it. And so my next question is, okay, are you using it? And if you're not using it, that's okay. But like I said, you have to plan to use it in the right way in order for it to be protected. So anyways, back to my example. Charlie calls me and he says, I love the name XYZ, protect it for me. I don't want anybody to take it. It's like near and dear to my heart. So, and it has like a bunch of, emotional significance. And so I say, great, Charlie, great. Let's file an intent to use application because you're not using it yet. And then a couple months down the road, Charlie says, okay, well, I haven't really started using it yet. I've only kind of started using a little bit here and there. And the truth of the matter is that Charlie's not truly invested in understanding how to protect it the right way. So lots of times what can happen is either you're not able to prove up the proper use of your trademark, and so the trademark office says, nix, you're not going to get your registration because you're not using it in the way we require you to use it in order to have a registered trademark. So then Charlie says, Marcella, what happened? I hired you to take care of this for me. And see, my point is that you have to follow the instructions from the get-go. If I tell you, hey, the proper way to use your trademark is to use it in this fashion. It's not according to how you think you should use it. It's according to the trademark guidelines. So if you're not prepared to follow the USPTO guidelines for how to provide proper proof of use in commerce, then, maybe you shouldn't be filing for a trademark. Maybe you should just have common law rights. And so everyone says, okay, well, then let's just have common law rights. What does common law rights even mean? So they'll say yes before they even know what it means. So common law rights essentially mean that you are not registering a trademark and you're just falling back on whatever rules would protect you since you don't have a registered trademark. And as you can probably guess, those rules are going to be, or those protections are going to be a lot more limited than if you had a registered trademark. So your protection is going to be about right here, and somebody who has a registered trademark is obviously going to have protections that are better, bigger, and greater than yours. And so you can't then be surprised down the road if you encounter trademark issues and you're wondering, why does, this person have superior rights to me if I started using the name first? So what are those rights if you start using the name first? Like I said, they are called common law trademark rights, but in layman's terms, something that you can understand, it basically means that you have the superior right to use the name in a specific geographical area where you are using the mark. So let's say you have a candy shop, or let's say you own a candy shop in Chicago, and you only sell to people in your neighborhood, to little kids, etc. So that means that you are protected in your candy shop name in the Chicago area. So anybody else who comes and establishes a candy shop exactly like the one that you have with the exact same name that you have, more than likely they're going to be told, hey, you're going to have to get out of here because I have common law rights to that name and I was here first. So you give them the boot. Now, if they registered a trademark and they were successful at registering it, you would still only be able to exclude them from the area where you were selling your candies first. So let's say that you, along with your candy shop, you also have an online shop, and you sell not only in Chicago, but you sell in California, Oklahoma, you ship to Florida, and you even ship to New York. So now it begs the question, well, does that mean that my common law rights now extend nationwide because I ship everywhere? And that is kind of an unanswered question according to trademark law and trademark cases at the moment. But I would say that if you are, selling to other parts of the country, then that probably would constitute use in the entire US, meaning that there is the potential for you to exclude somebody from selling under that candy shop name nationwide, not just in Chicago. But that's kind of, those are murky waters, and there isn't a straight line rule for what to do in those types of situations, but it is something to be aware of. So let's see. Do we have any questions? Okay. So one of the other most commonly asked questions that we get is, should I be registering my business name, my slogan, my tagline all together as one? So, if I have, let me give you an example. Like Nike, for example, they have their logo registered, which is like the check mark. Then they have Just Do It. And then they have, what is the other thing that Nike has? Yeah, the swoosh. I already said that. The swoosh is the check mark, and then Just Do It, and then the word Nike. So if that is the case for Nike, do you think Nike should be registering the swoosh with Just Do It with the word Nike? Well, the answer is, if Nike plans to use all of those trademarks together on one t-shirt or in marketing or anywhere, then yes, they should be registering it all as one. But the second question I'm about to ask you is going to be the most important one, because how often do you see Nike's trademarks all together as one, either on a t-shirt, on shorts, on hoodies? I mean, no, you always see it as like one at a time. Just Do It is on a sweatshirt. Nike is on a hoodie or whatever. It's always one at a time. So the answer is no, you're not going to register all of them together in one application. You should register them as you plan to use them. So let me see. Somebody asked here in the comments. How do I see the comments in here? If you want to ask your question again, that would be great, because I can only see it as it pops up. Let me see. Okay. So anyway, I want you to be aware of what it means to actually register a trademark and to protect your brand. And how long does it take to get registered? So right now I've had people calling me, telling me that they've spoken to other lawyers that say it's going to take like 6 months. And I said, I don't know what lawyer you were talking to, but it wasn't a trademark lawyer, because right now applications are not taking 6 months. Applications to get registered can take anywhere between 10 to 12 or 14 months. And yeah, that's a really long time. So you should get started sooner, because the sooner the better. The sooner you'll have an answer, the sooner you'll know if your mark is good to go or if it's in conflict with somebody else's mark. And we all know that that's kind of the burning question is my mark going to be in conflict with someone else's? Can you do trademark searches? Yes, you can. But I like to hear it straight from the horse's mouth, which is the USPTO in this case, as to whether or not you are able to use your trademark. And so there is nothing like knowing straight from the USPTO, no, you cannot use your mark. Why does it take 12 to 16 months? Well, because it goes through a process. It goes through a series of steps. So first, your application is assigned to a trademark examiner. Then after it's assigned to a trademark examiner, they review the entire contents of your application. And then after that, if there's an issue, they notify you through an office action. Then after that, you have a period within which to respond to the office action. And then after that, it gets published for opposition, meaning that if anybody wants to oppose your mark, they will. And then after that, it will get registered if you are entitled to get it registered. So that's why it takes that long, because it goes through a process. It's not just like one person checks in and then they're like, okay, good, they sign off. So let's see, I wonder if you're able to edit these live streams. I sure hope so. So anyway, go ahead and ask me your questions here, because I could talk all day long about trademarks, but I want you guys to be, is it something you can do yourself? This is like also one of the top questions that I get. Can I do it myself? And for that, I want you to go to trademarkanything.com. If you want to do this DIY process because you think, hey, I need to save some money, it's going to be cheaper, I'm not willing to spend thousands of dollars on a lawyer, which, by the way, you don't know if it's going to cost thousands of dollars unless you ask. It might even be cheaper. Anyways, so visit the link below, which is trademarkanything.com. It gives you the opportunity to walk through a very simple DIY trademark application at a very low cost. And you will understand everything step by step by step. It's very digestible, very easy, very simple to walk through it. So visit trademarkanything.com. So I think that's going to be it for today, guys. If this video was helpful, make sure to give me a thumbs up. And I hope to do one of these next week.